Thank you for inviting me. It's nice to be here. And I'm going to start very similarly to the morning's first comments that I'm unable to give you any answers, but I hopefully can raise some questions and give you reasons for some of the debates that we have in Estonia and also in the high-level expert group for the AI within the European Commission. Wait, the computer never works when it should. So my name, Karmen Turk, I come from Estonia. I'm an attorney at law and a partner in Pan-Baltic law firm. But most of my time, I'm not really a lawyer, but I work for Council of Europe, which was mentioned before, which is 47 member states and not the EU Council, as an expert regarding human rights and new technologies. And I also do work for the European Commission regarding everything that they are doing regards to AI as an external expert. And this is what I've been doing. But my practical lawyer's background is more litigation, human rights, strategic litigation, mainly in the Court of Human Rights and also in the Court of Justice. So I'm going to share my thoughts that we have had the debate in Estonia and in European Commission regards to what we as lawyers should think regards to AI. So, for every, I know I have like 25 minutes, 30 minutes.
Here is our daily
Yeah, 25 to 30.
25 to 30 minutes. So,
you are very well organized, I see.
I know. So, in general, for 25 to 30 minutes in every person's lives to be fruitful, you need to define what we talk about. So that's why I have these terms on this whiteboard. As already discussed in the morning, that there needs to be a very clear-cut understanding or trying to define what it is we talk about, because more often than not, we get lost when we use the term AI, because this is so abused term, it has no meaning whatsoever to anybody anymore for a long, long time. So regards to AI, you can see it as something that was discussed in the morning, as something a general AI, which is something in a far, far future, if ever at all, that is an AI system that would be smarter than humans in most of the domains or sectors. This is something we as humanity or engineers and on our technical level and skills will not be able to provide anytime soon, and it's more into the category of Terminators, Skynet and all those. So this is not what we're going to talk about. However, we are not discussing, when we think of AI, we are also not discussing what we as lawyers usually think that, well, it's just a software. It's just a calculation of if-then, so it is a software. But of course, when we talk as lawyers and have a debate on the ethics, liability issues, personhood issues, this is not something we talk about either. So we talk about this narrow, autonomous, intelligent system, which means that it is smarter than us in a very narrow expert sector. So this is something we are talking in nowadays when we think AI. It's something that does something better, but a very narrow thing, and it has no ability to switch domains. Meaning that if any algorithm is made to play chess, then the algorithm today is not able to change itself into starting to play, let's say, domino. So it's unable to change the domain. So this is an expert, autonomous, intelligent system we talk about. During past years, we have been very eager to use these new technologies. Very, very eager. We have many cases. Well, first of all, in personalized services. We don't want to see our society as statistics anymore. We want to take every person into account to provide better service, whether it's from the bank, from insurance, or from the state in the form of public e-services. We want to enhance customer experience in the meaning that we have chatbots that provide quicker, better answers to our clients, our customers. We have online dispute resolution chatbots trying to resolve simple disputes regarding, for example, insurance or consumer matters. We are very eager to use it in pattern analysis, mainly taking into account the big data, AML directives, so anti-money laundering systems, fraud detection, and all that. So we are eager and we are using those. And of course, process and document automation, another field where we have been very keen in trying to deploy these new technologies. However, there are some risks and issues that we should reflect when we use these technologies. Firstly, these algorithms are capable of creation, not in the meaning of what we generally see as an essence of an artist, but they are able to create. They are able to create poetry, they are able to create music. That is actually rather good. I invite you to listen to Aiva's first released album called Genesis. It's really, really good if you're into classical music. And this has been written by an algorithm, and it's the first algorithm in the world that was accepted as a member of a collective society in France. So algorithm getting actually royalties for use of its music. They also create art. Well, this is not very high-level art, but it gets better. It gets better. This is Google's Deep Dream. It's an algorithm that was firstly created for a very simple task. It was to show scientists and engineers, to give them an ability to see what a deep neural network actually sees when it is presented with an image. So the algorithm tried to create for scientists and engineers, okay, if you show me this image, or this one, then this is what I see. Of course, nowadays, this algorithm is used for much more, because it actually is rather great to look at, and these paintings are being sold for quite considerable amount of money. So they do create. Furthermore, they also negotiate, conclude, and are able to execute agreements. One example is this one. It's Trump and Dump. It's Twitter tweet analyzing algorithm that looks at the tweets from a president of United States and there's quite a few, yes, and tries to find whenever there is a mention of any company that is in a publicly traded stock market, and then tries to analyze the emotion of the tweet, and then makes the decision to sell or buy, and actually also executes the deed. So it negotiates, it concludes, and it executes agreements within a few milliseconds, quicker than anyone else, quicker than the stock market is able to actually react to the tweet itself. Furthermore, this is something that was also mentioned earlier today. This is something that every lawyer who is in this sector somehow cherishes a lot. This is this trolley problem that was mentioned before. But we do have algorithms making different ethical choices on our behalf. We don't even have to go to the autonomous and intelligent systems that are able to drive self-driving vehicles. It's enough to think of let's say, a robot judge or a system in US called Compass that suggests to the judge what is the probability of a person to be a recidivist, to do a crime again. So they do make ethical choices based on, well, we don't really know always. And furthermore, of course, we have algorithms to speak on our behalf. This is a Tay tweeter. It's a Microsoft tweeting algorithm that was released on Twitter to start to learn from humans, to be better than us. It took 1 day for it to get to this. The Tay tweet was closed because Microsoft was kind of hesitant whether they want to take on this liability, not only legal liability, but also moral and market value liability. So these are the risks that we do encompass when we are eagerly deploying these new technologies. So if you take account into the possible future and also relevant efficiencies that we may get from these technologies, but also take into account the risks, then of course as a lawyer, first thing you do is you start thinking about accountability, responsibility, liability, and you can't get out of the circle anymore, because this is what lawyers do, yes? So what about liability? Well, we have a legal system, regardless of what state we come from. I come from a very German-based legal system. This is a common law system. It doesn't matter what kind of legal system we come from, we still come from a legal system where we have human-based legal liability system. So this, if you think of it, the new technologies do not really have to change that. We have so many different forms to attribute legal liability. We have strict liability, we have no-fault-based liability, we have negligent-based liabilities. So we don't really need to invent new forms of liability. That has been suggested from time to time, also within the European Union. The Parliament's 2014 resolution was considering the possibilities of whether we should try to think of a new form of liability. I don't think it is needed, but I do agree with something that was also said in the morning regard to product liability directive, that as the high-level expert group on AI, there's also another high-level expert group that will release their exercise in June or July this year regarding whether product liability directive could help us, because of course there are many issues with that. We have a question of software, algorithm, whether it applies at all, and so forth. So we're going to know that, and of course I'm not really optimistic about the fact that the EU would open the product liability directive, because well, it's one of the longest standing legal acts soon, and I don't think they're going to open it, regardless of what will be said. But the responsibility and liability of human-based legal liabilities is, this is better. Wait, now it comes. So accountability and liability, on whose account and who's legally liable? Yes, these are the questions that we need to have in our mind. So regards to algorithms that are within autonomous intelligence systems, there are so many parties to how it is engineered, deployed, and used. Starting from engineers, then there is somebody who is deploying, whether it's the orderer or whether it's the seller or a marketer. And then we have a user. So one of the things that was discussed in the high-level expert group in the Commission, but is very heavily debated also in my country, because we are also drafting our laws for making legal environment more inviting to the AI systems, is that, well, in recent, let's say, decade or so, we have seen users as consumers, and consumers are always responsibility-free in our legal framework, in the meaning that consumers do not take on too many obligations, but the obligations are put either to the seller or the producer, and they have the obligation to explain and to explain and to explain to the consumer, for consumer to be free as a bird and able to use whatever the technology or device they prefer. This is probably something that needs to be reconsidered when we think of these new technologies. Because when a user, for example, us today, when we have a computer in front of us and the computer says, well, you need to update. Please click the here, it may take several minutes. We all know it usually takes much more. And we usually say, well, later, 2 hours later, 10 hours later. Can we do that when we have autonomous intelligent system that is capable of, for example, injuring another human being? Let's take self-driving car. Can the consumer do those choices anymore? That, well, I'm not going to update right now, regardless of maybe the traffic law act was changed in the midnight. I think this is something that needs to be changed in a paradigm of how we see consumers when they use these new technologies that are capable of causing huge damages to other people. So the other debate that is being had, and even for the sake of debate, I am not arguing for one or the other, but for the sake of debate, this is something that took for the high-level expert committee in the Commission also almost a year to have it debated, that what should we do regarding the legal personhood and so on. Because earlier, the resolution of the Parliament a few years ago, they were discussing electronic person as such, which is a concept that doesn't really have too much substance, but this was the discussions to be had. So for the sake of debate, if we take only the examples that were here a few slides back. For example, if Trump and Thumb sells a stock, is it the intent of an actual human being? We know that the liability can be attributed to a human being or a company, legal person, behind user of that algorithm. But can we go to the intent of that legal person or a person, human being in the end? Because intent theory is something much, much more concrete. Because for every transaction to be valid, there needs to be an intent towards a specific outcome, yes? So when you release an algorithm onto the Twitter that sells and buys, and there is no correlation to your specific intent, then can we say that this selling or buying deed from the algorithm is the intent of a person? So that leads to one of the debates that maybe, just maybe, the algorithm should be able to represent a person. Not every algorithm, but the algorithm that is made to execute and conclude agreements. Should there be a tightrope to represent a person? For example, in the world of, let's say, 10 years from now, when we have self-driving vehicles on our roads, then you go to work, you're in your office, and now you have your car in your garage waiting for you, or on the street, waiting for you to end work and then go home. Instead of that, if it is a self-driving vehicle, it could Uber, for example, the whole day, yes? Or go and change a tire while you are in your work. Or maybe you need some paint work. So the vehicle can actually go and have that done during the time the person is at the office. However, how can a car mechanic or the person who is ordering the Uber be sure that it's also an intent of me, the owner of that self-driving vehicle? So that's why there is a debate on this agency, the algorithm being able to be an agent of a person. There would be no having assets being transferred to the algorithm, but just the right to represent on behalf, on my name, and in the capacity of what I allow it. So that's the discussion that we are having quite heavily at this moment in Estonia, and it's called CRET laws in Estonia, and we are getting a lot of different recommendations from the Commission of EU saying that, well, don't go there, don't do that, you shouldn't do that, but just to share the idea that CRET is a mythological creature in our fairy tale history, yes? And it's this kind of creature that a person is building something out of nothing basically, in order for that thing to help that person to gain riches. And in the end, right always turns against the person. So it's not really best analogy, taking into account the ending of humanity and all those other possible predictions. But this is the discussions at least. But of course, when you take all this into account, then in the end, if you think that, well, legally, we are capable in our legal environments to accompany or take on board these new technologies, and we don't really need a reform of the legal environment, because the abstractness of our laws gives us ability to accommodate these new technologies. However, this is not the same, and this is not true for if you think of ethics. And of course, this is very difficult subject matter for lawyers, because we as lawyers, we more often than not put into the same pot ethics and law. Not all the law, of course, not the law of the land or law of the construction, but the human rights law that we see as something that is very profound in our humanistic history. So it's always difficult for lawyers to speak on the subject matter of ethics, because we tend to mix up the human rights, fundamental rights, and of course data protection is always there, and the ethics as such. That's why I think the EU Commission's high-level expert group on artificial intelligence also got sometimes a bit derailed. And if you have seen the final outcome that was released a bit back, it's also a bit mix-up. But when you forget that, then it's actually a perfect document to read on this matter. And why are ethics important? This is a simple algorithm that tries to understand whether the image is a cat or a dog. It's a very simple algorithm. They are getting better and better, as also said before regarding the dog and wolf algorithm. The problem with the algorithm, it seems to be, is that we don't really know what happens in there. So that's why we get the questions, legal questions of explainability, transparency, trustworthiness, human-centricness, human rights by design, and all those other institutes that we try to explain, or at least explain to ourselves, whether these are something that we want in future autonomous and intelligent systems. And of course the discussion is rather difficult, because in Europe we are not alone in the world, yes? There are other regions in the world. So we know that in the US there's more in the approach that, well, let's just fund it and fund it and fund it, and let's see what comes up. In China or in Asian region, there's another approach. Of course, funding is also a big part, but there's the approach that let's just get it done as much as possible and let's see what happens. So in Europe, we are taking the other approach, taking that, well, let's not overfund it, let's not over jump into it, let's first think of ethics. Of course, living in a global world, you need to ask that, is this really, in a long term, a right decision? Because the borders are still open, so we are not going to close down the borders and have only our ethical artificial intelligence systems, but we're also going to have all other kinds of systems. For example, one of the big discussions, as was also evident from the Parliament's resolution shown before, the first sentence is about Frankenstein and everything that is built after the face of human, and this seems to be a big debate in Europe. But is this really a debate to be had? That's another question, especially if we take into account the competitive edge and the ability to still be on the top in this new sector. But anyway, this does raise questions. And if it's a cat and dog picture algorithm, well, not really, it doesn't really matter. Well, it gets it wrong, so what? But let's go back to the example given before, the Compass algorithm in US. Do you know the case that went all the way to the High Court? Many different issues, yes. The producer, the engineer saying that, well, the algorithm is our trade secret. We are not going to release it. You're not going to know why it makes a decision. Then it's the journalists that publish an article saying that, well, this is a very biased algorithm. Not because we know why, but we do know the outcome. We do see that the probability of recidivism is always tied to a color of the skin and the region of where that person lives in. And there is no real good outcome in there. And in the courts, unfortunately, the US took a position that, well, it could stay like this. We don't need to see the algorithm. So the Europe is trying to think maybe we should do it differently. So this is the question of why we are so concerned about how does the pictures of cats and dogs are separated and how come the output is decided. So during recent half a year, all major international organizations have tried to tackle the issue one after another. And here I just decided to share that are, in my opinion, the most important ones. First one is from Council of Europe, the High Commissioner of Human Rights from just released a month ago. I was honored to be part of it, and at least the Commissioner did try to make it as simple and as practical as possible. And it's built only with these 10 key areas in mind, and this is mainly a human rights-based analysis of the possible implications. But of course, there are some questions of ethics that also come into play. The other one, and this I think is going to play a major role in coming years, is the IEEE's ethically aligned design. They are working out a standardization process against which a company or a state that are using these kind of technologies could measure and certify themselves against. They are quite far away already, and I can show you, I have the standard with me. It's like this very heavy, big book. I suggest you to read it if you have a real interest in it, and it's very well and practically written. And of course, as you can see also from here, the same problem, in my opinion at least, goes through. The ethics and law are intertwined into a big compost together. Not really sure how it will work out, because at least in Estonia, our school of ethics are very nervous about lawyers putting ethics and law all the time together, because the paradigms are different and the concepts are actually rather different. And the last but not least, the last draft that was released by the European Commission. And this is built up actually to try to help the companies as well as states within the EU when they are deploying these new technologies. It's built in a very simple way. It has 3 chapters. I'm not going to read you the guidelines, but just to give you an idea how you as a lawyer can also suggest your own clients, to help your own clients to make the best out of when they are using these technologies. We have already tried for some companies in Estonia. For example, one of them is Veriff. I think it's quite used in this region as well. An algorithm trying to use facial recognition technology to say the person is not a dog, but a person who actually is said to be in order to conclude agreements. And this guidelines helps for that company to self-assess whether their use of the technology is ethically aligned in that sense. So the realization of trustworthy AI is built together out of these 7 components, and these should be assessed through the life cycle of use of this technology, and should be assessed towards each other and in relation to each other, starting from transparency, accountability, and of course technical robustness as a cornerstone of use of these systems when the company or person using them wants to say that, well, we are taking ethics on board in order to ensure that these systems are used by us, but for all of us, and not against a human value or a set of values as such. So this was what the new work is. They are going to take on comments and going to release the final, let's say it's like a list of different assessing, it's like a list of 70 questions to be answered. So they wait for everyone to give some feedback, and they're going to release a final document in 2020. So now they are it's kind of like a second round of open consultation within the Commission. And they are waiting for comments from everyone. So if you have any clients or students that want to try it out, give it a go. So this was what I wanted to share. I have no idea how much I took because there's no clock. But I
You're
think
pretty
I was
well
in
back
time.
on time.
Great. Thanks.